SJC-11831, Commonwealth v. Brian Libby.
Good morning, Mr. Tennant.
Morning, Your Honors. Eric Tennant on behalf of Mr. Libby, and with me is Mr. Libby's trial counsel, Michael Farrington. We're on. Your Honors, in this case, the Commonwealth in this case is seeking to stretch the reach of involuntary commitment well beyond the statute's reach in a way that I argue was not intended by the legislature and in a way that falls really disproportionately and almost entirely on indigent persons such as my client. And in a way that, if interpreted, I think would raise some serious constitutional issues.
Now here, your client is not being charged with another sexual offense. It's a failure to register. But
correct.
Would it make any difference to your analysis if it had been another sexual offense?
It would not. The analysis is not based on what the person is charged with. It's based on where in the process that person is. And essentially the triggering event, for lack of a better term here, that the Commonwealth is relying on is someone's inability to make bail, whether it's because of means, because they can't afford it, they're indigent, and it might even be because of timing. You might have someone who can make bail, but I can't make it for another couple weeks, and the Commonwealth in that time comes in and petitions. And that's the problem. It's not the charge. It's that they're saying the legislature somehow expanded the statute dramatically to sweep in anyone who is simply pending a resolution of a criminal matter.
I agree that within the definition, a jail is within the definition of agency with jurisdiction. In other words, it isn't only a house of correction or a prison. A jail is definitely included, right?
And I noticed that, and I actually meant to try and do some research to see if there was anything beyond that. I understand what John is saying, that normally persons held pretrial are held at a jail.
Well, I think one couldn't disagree because it talks about keeper, master, or superintendent of a jail. So that's clear. So it's really, if you're going to use language of the statute before you get to the constitutional issues, it's really in 12A that you've got to find where you don't fall within this, right? In other words, not the definition of agency with jurisdiction. It's really 12A.
It's everything. It's the statute as a whole, and taking a step back and understanding how the statute was designed, sort of the mechanics of the statute. To address briefly the point about jail, the term jail, the way I read that is the legislature wanted to make sure that anyone who might qualify under the statute, that is someone who might qualify to be petitioned against under statute, may be held in different places because that happens all the time. And people are transferred from facilities for a variety of reasons. And so anyone who might have an eligible person within their confines has that obligation. But when you look at the rest of the statute, nothing else in the statute indicates that it was intended, that the people who qualify, if you will, were persons who were being held pretrial.
But if a person is held on bail as opposed to under a minimus, does the sheriff have the authority to direct the release of a person who's held on bail?
Under bail? I don't believe so. No.
So the sheriff would not be the agency with jurisdiction, would it? Wouldn't it be the court?
In terms of someone who's held under bail?
Yeah.
I think that's one good example of why the statute wasn't meant to apply.
So basically that would respond to Justice Botsford's concern that it's not an agency with jurisdiction.
In this context.
Well, thank you for the assistance. I mean, the problem is, again, this triggering, the fact of making bail, you don't know when it's going to happen, you don't know if it's going to happen, and it doesn't match with the statute's intention of basically trying to limit this towards the end of the process. If you go back to the prior statute that was in effect in the 50s and 60s, the one that was ultimately repealed, that statute was premised on, we're going to do this at the beginning of the process. We're going to do this when someone is sentenced and decide whether to commit or not, or sentence or not, and do it all together.
Does it make any difference if the person was held under the dangerousness provision of, what is it, 278, section 56A?
58A.
58A?
If they're being held because they are a pretrial detainee who happens to be held without bail because of dangerousness, no, that shouldn't matter either. Again, that is not a person who fits within the class.
And what if they're being held for a violation of probation? Does that matter?
Again, no, that shouldn't matter because that is essentially the equivalent of pretrial. It's a finding of a violation of probation. In both those cases, or any of those cases, If someone is convicted or violated on probation, then the statute kicks in and we know how to deal with that and notify the Commonwealth if they want to try and petition against the person. And again, that's how the statute, when it was reenacted in 1999, is meant to apply.
What about the Gillis definition of what is a prisoner?
Gillis, and so I obviously this court knows its own cases, but when Gillis talked about a prisoner,
I wouldn't count on that.
I did notice that there's only 2 judges who weren't here during Gillis, but when Gillis talked about a prisoner, Gillis quoted the dictionary definition of prisoner and said, by terms of, I don't know, the Oxford Dictionary, Black's Law Dictionary, a prisoner is someone incarcerated or awaiting trial.
Or awaiting trial.
But,
And then went on to talk about other things having to do with that.
well, 2 important responses to that. But the court said, that is not our definition of a prisoner. That is not the statute's definition of a prisoner. They're not the same thing. The statute has to be construed narrowly and must have a narrow definition. But also, when Gillis went on to talk about someone who was charged with an offense who might be eligible for commitment, it was very clear that what it's talking about and what the statute refers to is someone who is charged but found incompetent to stand trial. The statute does envision someone who is charged potentially being in that class, but it's only people incompetent to stand trial. And again, that makes sense when you think about how the statute works. It makes sense because that person's criminal case...
Judge Cowan also says, because they've been charged with an offense and are awaiting trial, such persons also fall squarely within the ordinary meaning of prisoner and are awaiting trial.
Again, the dictionary definition of prisoner, but not necessarily the definition of prisoner, or more importantly, the way the class of persons the statute says are eligible for commitment. Don't forget, the statute itself defines a sexually dangerous person as 1, 2, 3, and those are essentially the class of persons that are eligible. Number 1 is someone who has been convicted or adjudicated of a sexual offense. We all agree with that, and they're serving a sentence, and at the end of that process, you can petition. I'm going to skip ahead. Number 3 is someone committed to DYS. Number 2 is someone who has been charged but found not competent to stand trial. Those are the only persons who are eligible to be committed, or I should say the Commonwealth can petition against. And that's the only place the statute talks...
Not someone who is held without bail.
That is clearly not within those 3 definitions.
So, held without bail.
Held without bail, held because they can't... And basically,
held without, there is no bail. You're held as a dangerous person. They're held as...
No, because that person is simply charged awaiting trial. The reason they're held is without bail because they're dangerous. Maybe it's because
a condition of probation or whatever.
Correct. Maybe they can't make bail, whatever it is. But
forget can't make bail. They're held without bail.
No, I understand. I'm saying those are all the different reasons why someone might be held. But what matters is the reason they're into the system is because they're simply charged and haven't been convicted yet, haven't been gone through that process. If you think about it, perhaps the most absurd thing about this is the only people who would be affected by this are essentially those found not guilty, ultimately. Because if you are charged with a crime and convicted, at that point, everything kicks in and the Commonwealth will have a chance to petition if they see fit. If you are charged with a crime and found not guilty, but you had allowed the Commonwealth to petition during that time period, then the only people who are going to be sucked into this are those who are ultimately found not guilty. And that seems horribly absurd that the legislature would want to create that class of persons as eligible for commitment, where the only reason was something that they're ultimately found not guilty of, whatever the charge is, serious or not serious.
Don't you think, though, Gillis has some problematic language for you? In another part of Gillis, the court says, put differently, the 2004 amendments authorize SDP commitment of any prisoner who has ever been convicted of an enumerated offense. The amended language does not, however, apply to defendants not serving any sentence who have no criminal charges pending against them.
Again, I mean, I think that language is, I say sloppy, not in a bad way, but it wasn't the issue presented, and Gillis was juggling a couple different things. When you talk about charged or not charged, not serving any sentence, again, Gillis later specifies there is a section where we know the statute allows you to go after someone who is charged not serving a sentence. That's someone who's been found not competent. This obviously issue wasn't in front of Gillis, but understanding again, let's talk about from McLeod to the amendment to Gillis. We know that in McLeod what this court said was you had to be serving a sentence for a sex offense. The legislature, in direct response to McLeod, fixed that with this language. That was the intent of that. For them, they wanted to say, no, we want you to be able to go after someone who's serving a sentence for any reason, and therefore created that language for any reason. And then Gillis came in on a slightly different scenario just to explain what that language meant. But more broadly speaking, we know that language was meant to fix that one problem in McLeod and not all of a sudden open the door as broadly as the Commonwealth.
This is dicta, and to the extent it says otherwise, you're saying it should be corrected.
Absolutely, it's dicta to the extent that anything in Gillis is seen as applying here and allowing this. That was not before Gillis, and they were not asked to do that. I think the fair reading of that language is what I've said before, that we're quoting dictionary definitions, or there's references to places where someone can, pending a charge, be committed. That's someone who's found not competent to stand trial. I think that's as much as you can get out of Gillis.
Can I turn your attention to the statute in 2004 which amended it, which is, I guess, the key language?
Yes.
Did you find any legislative history with regard to that?
I did not.
Am I not correct that that language was added after the murder of Alexandra Zapp at the Bridgewater rest stop by a gentleman, Mr. Leahy, who had previous sexual offenses but had just been released from prison on a non-sex offense, and the DA's office said, there's nothing we could have done under the current law, and then this language was added to address that issue.
It may have been. I honestly don't know, and I have no reason to doubt that. But that's exactly right.
That's correcting McLeod.
That is, the amendment was there to fix the McLeod decision, or not to fix, but to allow for a broader application that this court did not allow in McLeod. And so you have the McLeod decision, you have a concrete example of it, and the legislature says, we want to fix that so that someone who is serving a sentence for a non-sex offense should be eligible for commitment, and they did that. And that is what that fix to the statute did. That is what is in practice now, and persons who are serving sentences for anything can be petitioned against, and often are, and there is no constitutional problem with that, and so it has moved forward. What the Commonwealth is doing here is taking that language intended to fix that and applying it broadly in a way that I've not seen before, in a way that raises, again, many of the issues I've addressed. That is, it applies rather absurdly. It creates results where the class of persons who are affected are disproportionately indigent, ultimately innocent of a crime if it plays its way out. It raises serious constitutional questions, and it seems I cannot imagine that small legislative fix was meant to open all this up.
Let me ask you, because some of this does not have anything to do with indigency, it seems to me.
That is correct, and my petition and my client is being held, I should say, my client, the reason he cannot make bail is because he's indigent.
Right.
And I presented the 211-3 petition narrowly because that's not a dispute here. That here, if they were allowed to go forward, it would be because he's indigent.
Right.
And
But
the court
let me ask you a question about that. If he were suddenly to be, some benefactor came along and paid his bail, would the SDP still proceed?
If there is, would the SDP petition proceed?
Yeah.
Okay. Are you asking right now as it stands, or had it happened prior?
Had it happened prior that,
It could not, and that is the absurdity of it. If he had been able to make bail, or if he had been released on his recognizance, or anything between then, he would have been out, and he would not have been in custody, and the Commonwealth could not have claimed that there was an agency, that he was a prisoner, to file the petition.
in the period before bail is set?
I can't. I mean, it's a 1 day.
This is really a broader question, though, about what it means. So that's why you're focusing on pretrial incarceration.
Correct. The way it happened in this case, and the way it would play out generally, I think, is it's going to apply to persons who cannot make bail, either for any of the reasons we said,
Or because bail hasn't been set.
or for bail hasn't been set. I suppose that's another reason. It's such a narrow window, the time period in which bail has been
Well,
set.
no. What about a dangerousness hearing?
Even that is technically narrow, has to happen within 3 to 7 days. It would be hard to imagine the Commonwealth having a petition ready, but in theory that could happen.
So that doesn't pivot on the
No, the
destitution issue.
Correct. Again, the 211-3 was drafted narrowly because that is the reason my client is being held. That is the reason he could not make bail. In fact, the civil commitment petition came many months, if not longer, after it was set. So could he, had he had the means to make bail, he would have made bail and walked out.
How long's he been held currently?
You know? Do you know how long he's been held? A year, I'm being told.
Now, he's being, there was a, I guess in April, there was a trial date that was set,
I believe it's set in July, sometime in July for the criminal case.
and if he's convicted and he's sentenced to jail or prison, then they, even if you
They can do
prevail
it.
here, they could initiate the SDP upon his
Correct.
release then.
But they would need to do it that way. I mean, it doesn't moot anything here at all. I don't think.
Right.
The petition as presented is invalid, but if convicted, correct, then that's where the
Except if
statute.
he's not still in prison because it'd still be released because of time served.
That could be.
I'm sorry, I didn't catch that.
Except if he's released because of time served.
But the petition has been filed with a detainer, so he's being held on both at this point, essentially.
I'm just trying to figure, okay.
No, okay, all right, thank you very much.
Thank you.
May it please the Court, John Anya Seltzman, Assistant District Attorney, Plymouth County DA's Office for the Commonwealth. Good morning, Your Honors. The question presented here today is whether a prisoner, specifically the respondent, Brian Libby, who is held in pretrial confinement, is a prisoner subject to commitment as a sexually dangerous person. And if Your Honors would allow, just very briefly, the statute, Chapter 123A, authorizes commitment to a treatment center any person who, one, has been convicted of an enumerated sexual offense as defined in Section 1 of 123A, and two, any person who suffers from a mental abnormality or personality disorder that makes this person likely to reoffend sexually if not confined to a secure treatment facility. And the procedure for the commitment begins with a report by any agency with jurisdiction of a person who has been convicted of a sexual offense as defined in Section 1, regardless of the reason for the current incarceration, confinement, or
But
commitment.
does that refer directly back to who's ever been convicted of or adjudicated? Because there's a second part that says, or who has been charged with such offense, because it seems to me that the statute contemplates situations of pretrial confinement, but not this situation.
My understanding of 123A is I have to have someone who has a prior conviction for a sexual
You
offense.
have to have a prior conviction, but the question is what whether
You're being
you're
held, are you being held just because you're a competent person being held pretrial, or are you an incompetent person being held pretrial?
That's not my reading of the statute. It states.
It does make a difference between people who are convicted or adjudicated and people who've been charged with any offense.
And specifically, that would be Section 12 of 123A, that an agency with jurisdiction of a person who has been convicted of a sexual offense, regardless of the reason for the current incarceration, confinement, or commitment, it says, or who has been charged with such offense but has been found incompetent to stand trial, or has been charged with any offense who is currently
Charged with
incompetent.
any offense.
So I'm reading that as or, whereas Mr. Libby here has been already convicted of an enumerated sexual offense, the indecent assault and battery on a child under 14.
That's not what he's confined for.
No, he is confined currently for a criminal matter, the failing to register as a sex offender, the subsequent offense.
Well, what do you say to Justice Spina's point, though, that agency with jurisdiction, the person in control, that is the superintendent of the jail, has to be able to direct the release of the person? The superintendent doesn't have the power to direct the release of somebody being held pretrial?
I would assert that the agency in control is either the House of Correction, the superintendent of the House of Correction, the Department of Correction, the parole board.
Release somebody pretrial?
Are you referring specifically to Mr. Libby, who has...
I'm referring to somebody who is either who. I mean, the judge could lift the conditions of bail. I mean, the judge could lift this and say, you know, he's free on his own recognizance,
This is
right?
true.
I mean, but nobody else could do that.
Right,
So only the judge could do that.
at the moment.
At the moment, the judge could reduce his bail or set bail at personal recognizance, but he does, the respondent does still have the petition for temporary detention.
But that could have happened at the beginning, right? I mean, so you're saying that who has control, who has jurisdiction over this person?
I would maintain in this situation the House of Correction.
Well, I mean, certainly the superintendent of a prison doesn't have the authority just to release people, right? I mean, superintendent can't come in one day and say, you know, you 10 guys, you're gone. I'm releasing you. There's got to be some process.
That's correct.
Either a parole decision by an executive agency or some ruling by a court.
That's correct. And
It's a little confusing what this means, actually.
the agency with jurisdiction.
Right.
I understand the point that who has jurisdiction over the respondent, whether it's because bail is imposed, whether it's the court or whether it's the superintendent of the House of Correction. I do know that prior to an individual such as the respondent is released, I am contacted to see if I do want to file a petition against someone who has possible exposure to Chapter 123A as a commitment as a sexually dangerous person.
Now, am I correct about the context of the addition of the language in 2004, that it came in the wake of the Zapp killing and the criticism of, I think it was your office, for not having brought an SDP action, and your office saying our hands were tied, we couldn't do that? Isn't that the context?
I apologize, Chief Justice. I am not sure if that was
Probably
the
before your
case that-
time.
Not sure she was born.
Okay. Do we have any indication that that the legislature intended by the addition of this language to include those who were charged but not convicted?
I think the legislature was clear in the 2004 amendment when it was amended in that year to saying that the SDP statute to apply to any person that has been convicted of a sexual offense, regardless of the reason for the current incarceration or confinement.
Except that regardless of the reason really goes back to the whole purpose of the amendment was to ensure that even if the person was incarcerated for a non-sexual offense, as long as they'd had a previous conviction of one, that regardless of the reason for the current incarceration, they could move forward, not regardless of the bail status.
But I believe the statute on its face is unambiguous when it's made applicable to any prisoner.
So are you saying that if bail had not yet been set, for example, awaiting a dangerousness hearing, that the Commonwealth could come in so long as the person had once upon a time been convicted of a sexual offense and bring an SDP petition, assuming it can be done in a timely manner?
I believe it would be...
even before a bail decision is made?
I think I would need three factors in place before I'd be able to do that. One would be that the respondent be in confinement, either House of Correction.
He's in custody.
In custody. Two, that he have a prior enumerated sexual offense. And three, his present mental condition. Does he presently have a mental abnormality or personality defect?
Yeah, but I mean, the question though is this really in any pretrial detention? Anyone in any pretrial detention could be on your theory under this an SDP petition could be brought in because that person's a prisoner?
I believe so, as someone that's held...
Just the mere fact of being in custody?
I would believe, yes, if someone is in custody, my reading of the statute, I would be permitted to file a 123A petition against.
Then how do we harmonize the 6-month provision?
Yeah.
I think those are, Your Honor, guidelines of... my understanding of the statute is that the agency is to notify the district attorney's office within 6 months of a person's release. I know that I am notified many months prior. I don't believe that the language in that statute would prohibit me from filing against someone who isn't set to be released for 9 months or a year. I believe those were just guidelines that were set in place.
Doesn't the fact that the legislature put in the guidelines about when notice was to be given, and all the guidelines really go to somebody who is being held as a convicted prisoner, that it did not intend 12A to be reaching pretrial detainees?
I would turn to the language that this court ruled on in Commonwealth versus Gillis. And in that case, this court said that the key operative fact is that an SDP commitment is only available if the procedure is initiated before termination of a period of criminal confinement. If not, the statute no longer applies. I believe someone that is held in custody, and yes, in pretrial detention, is in a period of criminal confinement.
Well, you can't give the notice in those situations, the 6-month notice, and the legislature deals with this by saying that there are two situations where you don't have to do 6 months notice, only 2, and doesn't include in that people held in pretrial incarceration.
I think the fact that the legislature did not carve out a specific exception to it is my understanding that people held in pretrial detention are included within that class of people that are have a current incarceration, confinement, or commitment. I think they're very specific in separating that from confinement to commitment and current incarceration. I believe someone held in pretrial detention would be within that class.
Because this is a statute that is in derogation of liberty, don't we have to read it narrowly? Isn't that what we said in Gillis too?
I believe, Your Honors, that it should be read narrowly, but I believe the plain meaning of the language is already quite narrowly tailored to meet the legislative purpose. And I believe that the SDP statute was meant to be not punitive or penal, but more rehabilitative. I believe that the issue is, number one, protecting the community from people who are deemed to be sexually dangerous. But the dual goal, I would submit to the court, is to provide treatment and rehabilitation to individuals who have the previous sex convictions and also have a current...
Who have liberty interests, those people.
Yes, I agree that they do have liberty interests, but I believe that the legislature did not mean this to be punitive.
But the legislature has been specific in laying out when you don't have to give 6 months notice in its language. I mean, I don't think we're seeing it as being as clear as you seem to see it as being, that this applies to pretrial detention.
Again, the fact that the legislature did not carve out an exception to people that are not, that it applies to all these people except not people who are held in pretrial detention, my understanding would mean that it does apply to that. As a matter of fact, there was an exception that people who are held, who are civilly committed, this statute does not apply to. So there was an exception carved out for people who are just simply civilly committed but that don't have criminal cases pending against them or are awaiting trial, which I would submit that the respondent in this case is awaiting trial.
Is there any possibility that somebody civilly committed would be likely to be discharged from that commitment within the 6-month period that would also preclude notice, the notice that's required by the statute?
I'm so sorry, if I could have that one more time.
So I'm trying to understand your argument about the 6 months, that it's a guide, and ask whether, because I don't know the answer, is it possible that a person could be civilly committed, having been charged with a crime but found incompetent to stand, and therefore not incarcerated but confined, that individual might be released or not, because then they would then be moved to a different kind of confinement once they become competent? Does the 6 months apply or not to someone in that circumstance?
the notification to,
Yes. Is there a possibility that there would not be a 6-month window within which to provide notice to the DA?
I know of situations where I'm notified of an individual's impending release and their date is moved up for good time. I know that that's not really addressing what you're asking me right now, but sometimes that window is cut short and I have to move quicker if I'm...
Less than 6 months?
Absolutely, yes.
Okay.
Yes.
Let me ask you another question. Now, you have, you get somebody who is, whether it be as a result of not being able to meet bail or, you know, that maybe there is no bail decision yet made, and you bring the petition, the SDTP petition, on the theory that this is a person in confinement and meets the criteria of the statute. What happens if somebody makes bail? That makes no difference to the pendency of the SDP petition? It's brought, and that's all you need to do is just bring it, and then you're good to go?
If I file the petition prior to someone's release from custody or confinement...
Doesn't matter if they're then released from custody or confinement.
Correct, there will be the detainer, the 123A detainer on that individual, as long as it is done before the termination of confinement.
Okay.
All right, thank you.
Thank you.
All right.